Hi, I'm Deirdre Vervo. How are you? Thanks so much for joining us in Let's Talk Seniors, memory care issues, dementia, Alzheimer's, and Parkinson's. For those of you who do not know me yet, kind of far up here, I wrote a book called I'm an author and a senior advocate, senior home specialist, and I wrote a book called Home to Home, the step-by-step housing guide, and also a big senior planning workbook guide. If you'd like a copy, they're sold on Amazon, but if you'd like a copy, my goal was to go to all the senior centers and have workshops and give them out. They were all set up, but COVID, so nothing happened. So if you'd like a copy free, my name and number will be at the end of this Facebook Live, and just write to me, call me, email me, and I'm happy to send it to you. So we have very exciting things going on here. We're going to be talking all about seniors and senior issues. And we have a special guest tonight I'm excited about. Again, if you have questions, please do not hesitate to ask them. Just write down below, write your questions, and we'll be answering them. Tonight's special guest is Paul Bologna. He's an attorney and CPA practicing in Connecticut. He is well-versed in various specialized areas and is an advocate to seniors. This gives Paul Bologna Associates an edge when dealing with complex legal matters. Often more than one area of expertise is required. Along with asset protection, he does elder law, real estate, family law, and trust and estate planning. One-stop shop. I've known Paul for about a dozen years now. He brings a wealth of experience and knowledge from all angles to everything he does. And tonight, he will be demystifying Title 19 for us. What the spend down process is, how it works, what it means to your loved one. So please feel free to text below. And let's now welcome Mr. Paul Bologna. Hello, Paul Bologna. How are you?
I'm well, Deirdre. Thanks for having me tonight. I appreciate the
opportunity. You're welcome. Thanks so much for joining us. And why don't you tell us a little bit about how you got into elder law and estate planning and what that means to you and for us?
Sure. Well, years ago, I was practicing CPA and had the opportunity to work on some Forbes 400 individuals regarding trust and estates. And so when I became an attorney, I started trust and estate practice. And of course, trust and estates is probably the closest area to elder law. And we saw the need to provide the elder law services. So that's how I got involved with elder law and Title 19 and Medicaid planning that we're discussing tonight. I can't stress enough the need to plan early and plan just with regard to what's going on today with the COVID-19 crisis. We've had clients calling us up, desperate to have wills in place and trusts in place and Medicaid planning. And unfortunately, it's been difficult to accomplish these things as business as usual. So we've had to adapt like everyone else under the circumstances and do online consultations and also online signatures for wills and various other documents that are needed to be put in place so that people are prepared for when things do happen. So I think the COVID.
Why the big rush right now?
The big rush because of the COVID-19 and the idea that people are scared of their health. They're scared of the statistics that are out there, and they saw the urgency to have something in place. We work with a lot of clients, and although many clients avoid wanting to do what really needs to be done in terms of estate planning and Medicaid planning, the COVID has shown them that the sooner the better for all this type of planning. Because
I totally agree. I think it's brought people to the realization that we're not going to live forever and anything could happen, whether it's COVID and could be dead in a few weeks, or anything else could happen. And it's hitting home a lot. I just did my estate, my trust, my everything too, because of this. It just hits home that we need to be prepared because anything could happen.
Oh, absolutely. And especially when it comes to Medicaid planning, many of your uh, viewers might be aware that for purposes of Medicaid planning in Title 19, there's a 5-year look back. And so
Ah,
that's a real reason to plan early in this area of law, because many times coming to us at the last minute, although we still can do some planning, we don't take advantage of what we really could accomplish for clients if we had a 5-year or more of a window. And
so why,
so,
why don't you explain that in layman's terms, what the 5-year look back is and what they'd have to do to get that?
sure. Well, as you can imagine, there's a lot of uh, fiscal constraints on the part of the state, and the states are the ones who provide Medicaid benefits. And so, years ago, um, people would try to give their assets away at the last minute in order to qualify for the Medicaid benefits. And then a 3-year rule got put into effect where if you gave assets away within 3 years of needing Medicaid benefits, you would be disqualified.
Mm.
And now, of course, it's a 5-year look back, which means that if you've given assets away within the last 5 years prior to applying for Title 19 Medicaid benefits, you could be disqualified or your Medicaid benefits could be delayed.
And
So
is that a federal or is that state by state?
it is it's the portion that's federal is Medicare, the state is Medicaid, and they set their own rules in general for this. But almost every state has, including Connecticut, has 5-year look back.
When you say give away, you don't actually have to give away your money. You could put it in the state for your purposes, right? And still be in control.
Well, I mean, it could be as little as gifting money. You might go to your accountant, and your accountant might say, "Oh, well, under the federal tax law, you can give $15,000 a year," and that might be true. But under Medicaid, a $15,000 per year gift could disqualify you for Medicaid benefits. So
Wow.
it's nice to be able to give the annual gift tax exclusion amount away, whether it's to your kids or to grandchildren, but it can come back to haunt you for purposes of Medicaid planning. And so those are things that we take into consideration so that we can accomplish both of getting money to children, grandchildren, and yet not disqualifying people. So any time you're thinking about gifting, whether any amount over $1,000, you should be speaking with an attorney to see that, number one, that the gift is exempt for tax purposes, and more importantly, that it's exempt for Medicaid purposes. Because all of a sudden you think you're going to rely on Medicaid benefits, and then you're disqualified and you have to pay for it yourself.
So not to jump ahead, because I know you're going to talk about Title 19 and trust, but if you have your money in a trust and it's been in there more than 5 years and you give away this gift of like $15,000 a year, could you still be disqualified?
That's a great question. And it comes down to what type of trust. If it's, for instance, a living trust, which is a revocable trust, you get no tax benefit from a living trust. You get no Medicaid benefit from a living trust. So in that sense, those gifts would disqualify you from Medicaid benefits. However, if it was set up in an irrevocable trust, or what we call a Medicaid trust, where it specifically was not set up for your health, welfare, and benefit, and is controlled independently by trustees, then that's the type of trust that could help save your assets from Medicaid.
So what is the difference? Are those the only two types of trust?
Well, I mean, there's revocable trusts and there's irrevocable trusts, and this would have to be an irrevocable trust, but it would more importantly, it would have to qualify for Medicaid purposes. So a trust like that would look like this. Number one, you'd have to transfer the assets 5 years prior to applying for Medicaid. And number two, the language within the trust could not have language that's ordinary in an irrevocable trust that says this is for your health, welfare, benefit, education. It would have to be controlled by trustees that would have the power to either deny your request for money or grant your request for money. And so it's very strict. And so the balance here is putting your money in trust, but also being comfortable with losing a certain amount of control over that money, because it's very difficult to maintain control over your assets and yet still qualify for the Medicaid benefits. So you have to be able to make that choice and live with that you have independent trustees set up, or you have children that are trustees, and that you trust those children that when you do request funds, they're going to be granted to you. And when you request funds, sometimes you want them denied so that Medicaid will pay. Because the first thing Medicaid will say, or the state will say, is, well, you have $1 million in an irrevocable trust. Use that money. And you, in essence, have to come back and say, well, that's controlled by independent trustees, and I don't have a choice of how that money gets distributed. Only the trust.
We have Robin asking about, what about a family trust? How does that differ?
Well, a family trust is no different in the sense that it may be a trust that's set up to benefit various family members or to hold various assets, and that can be good for tax purposes and for probate purposes. It may be a positive, but then for Medicaid purposes, if that family trust benefits the Medicaid applicant in any way, then that trust could disqualify that Medicaid applicant. So it's a great question when setting up a family trust, understanding the impact, not only the tax impact, the probate impact, but also the Medicaid benefit impact that people usually don't consider.
So is it safe to say that the only trust that's really for the benefit of Medicaid and the 5-year look back is the irrevocable?
It would have to be an irrevocable trust, and it would have to be a trust that didn't have language in it that whereby the grantor or the Medicaid beneficiary could say, I want X dollars from this trust. Because if they have the power to do that, then the state's going to say, well, we want you to go and get money from your trust, and we're not going to give you Medicaid benefits.
So why would somebody set up an irrevocable as opposed to a revocable? You said there were limitations on irrevocable. What kind of limitations?
Well, with regard to a revocable trust, revocable trusts do not protect assets from Medicaid. So any monies in a revocable trust would be subject to the Medicaid limitations, which we'll get into a little later. But number one, what revocable trusts generally do is organize your assets and potentially avoid probate on those assets. And that is a benefit, but there's really no tax benefit in a revocable trust, and there's no Medicaid benefit in a revocable trust. So the only type of trust. Is
it not a tax benefit just because you're not going through probate? Because doesn't it go directly to your heirs?
Well, yeah, I mean, but there isn't a specific meaning. Just because you don't probate an asset, your assets are still subject to federal tax and state tax when it comes to estate tax. So having your assets in a revocable trust does not minimize your estate taxes at the federal estate level. It just puts all the assets in one place, and it helps to avoid probate on those assets, which is a benefit in and of itself, but it's not part of Medicaid planning.
So with a revocable trust, the person that sets up the trust, they have control of it until they pass?
Yes, in a revocable, they generally have control of it.
And what about an irrevocable trust? What is the deterrent to setting that up?
Well, no, in an irrevocable trust, you certainly can set that up. Generally, irrevocable trusts were traditionally used for estate planning to get the asset value out of your estate. And it does that for federal tax purposes. It gets the asset out of your estate, and it allows the growth of those assets to grow outside of your estate. So it does minimize estate taxes. But if it's just set up as a traditional irrevocable trust, it's not going to benefit you for Medicaid purposes. It has to be special language in that trust that limits your access to that trust and therefore allows you to qualify for Medicaid benefit.
So my mom set hers up when she was like 57. She's 83 now, and she has an irrevocable trust.
Right.
But she seems to have full control. Like if she wanted to sell her house, I guess she'd have to ask, the kids. But we've never had anything to do with her trust because she's still alive.
Right.
So what control doesn't she have at the moment?
Well, I mean, I'd have to look at the trust document. If it's set up as an irrevocable trust, she would have a trustee. She couldn't be the trustee of her own trust. And
But
so,
my brother and I are the trustees, but we've never had to do anything.
well, because she's never made a request. And I don't know if she's on Title 19 or has applied for it in the past. But
No.
if she applied for Title 19, the state would look at the trust and the language of the trust. And to the extent that your mother-in-law was allowed to request funds or allowed to exercise certain powers over that trust, that money would be available for her care. And therefore would want her to use that money prior to paying out any benefits.
Okay, so why don't you tell us exactly what is Title 19, and is that the same thing as Medicaid?
Right. Title 19 is basically the federal program under Medicare that gives block grants to the states to use in the state Medicaid program. And so the states are allocated block monies for purposes of Medicaid benefits. And Title 19 provides that states will provide benefits for those who can't afford to pay for purposes of elder care. And that might be, traditionally, that's nursing homes. And it could be, there's some home care programs set up now, and also may be applicable to assisted living facilities. So there's various programs under Medicaid that would qualify for the program, and therefore benefits could be available. Now the question is availability, and what does it take to qualify for those benefits? And so the state lays out specific amounts that you have to have or not have in order to qualify for Medicaid benefits. So I'll just give you an example that you take a married couple where one spouse needs a nursing care facility and the other spouse is considered the community spouse. They don't need that care at this stage. And the state will only allow the community spouse to have $128,000
In assets.
in assets.
What about equity in a house?
Okay, we can talk about assets that are exempt and assets in general. But $128,000 would be assets that the community spouse is allowed to have. The institutionalized spouse, the one that's applying for benefits to go into a nursing home, would be entitled to $1,600 plus or minus. That's all the assets they could have. And so you see how strict it is in terms of qualifying. And that's set up so as to not completely impoverish the community spouse, to say, well, the community spouse has to live, they still have to live in the community, they still have to maintain a home, and therefore we're going to allow them to have a certain amount of assets. Now you mentioned a house.
Yeah.
So when it comes to equity in the house, a house is considered an exempt asset. You're a married couple. So a married couple, the house is not considered an asset, and up to, for 2020, it's now $893,000 of equity that would be exempt. for purposes of Medicaid application.
So let's say you had a house that was worth less than $893,000. You have nothing on it, and you had more than $128,000 in the bank, the community spouse. Let's say you had $500,000 in the bank.
Right.
What happens?
Right. Well, that's where the planning comes in terms of how are those assets titled, and what amounts do you have to spend down. And when we talk about that's one of the things we wanted to talk about today is how do we spend down these assets. So first and foremost, the spouse applying may have too many assets because they have to get down to $1,600. So it's clear that they probably have too much in terms of assets. What can they spend their money down in order to bring the number, let's say, from 50,000 down to 1,600?
So,
And,
Paul,
yeah.
this, unlike in a marriage where your assets are combined, this is taken into consideration how they're titled.
It can be when it comes to various assets like pensions, 401ks, IRAs, and things of that nature. And so, as part of our planning, we go through that and make sure that the assets are titled in the best possible position. Now, sometimes that doesn't always work because, let's say, for instance, the husband's 5 years older than his wife. He's the one that is potentially going to a nursing home sooner rather than later, and we plan to put more assets in the spouse's name, the wife's name, and the plan is perfect until, of course, it's the wife that has to go into the nursing home before the husband.
Yeah.
And so it can get real tricky when it comes to that. And so we have a lot of tools to get assets out of the estate, whether it be irrevocable trusts or spend downs, and then with the remaining assets, how to title those assets to best predict the future. There's no guarantees in this type of planning.
Can you retitle somebody's 401k and their pension?
Well, that's
the spouse's name.
That's very interesting because those were assets that were typically thought that you could not retitle them. And there's something called a quadro, a qualified domestic relations order. And we know about quadros through my family practice because when couples get divorced, many times a pension or 401k is divided through a quadro, through a qualified domestic relations order. Matter of fact, traditionally, some couples, elderly couples, were forced to get divorced in order to qualify for Medicaid.
Wow.
And that's unfortunate when situations, occur. But this technique allows basically an in-marriage quadro. It is relatively a new technique where you can be married and still transfer pensions and 401ks between spouses. And that can really benefit you in Medicaid planning, allowing a spouse to obtain Medicaid benefits much earlier than they would if they had this pension and 401k in their name. So it is possible.
But if you do that, Paul, is there a tax ramification like today? Like if you were to do it this year, do you have a tax ramification the year you do it?
And that's a great question because almost everything you do has multiple ramifications. From a tax perspective, there is no tax consequence because it is a transfer between spouses and it is a quadro, qualified domestic relations order. Meaning if you took the money out and then transferred it, there'd be tax consequences. But because you're transferring it through a quadro, there are no tax consequences. So that's a major benefit of a quadro. And this is.
Can anybody do a quadro if they're married?
Well, it wasn't thought that anybody could do quadros except in divorce situations. But recently, quadros have been found to be allowed to be done in marriage. So we recently did one whereby The husband had a pension, and we knew that he was going in sooner rather than later in terms of a nursing home and needing Medicaid benefits. And we were able to do a quadro, draft a quadro, coordinate it with the pension plan, and get it approved by the court, where a judge would sign off on the quadro, and then the pension plan would effectuate the plan of transferring it. So now all of a sudden, that pension plan is no longer in the husband's name, but it's in the wife's name. And
That's really interesting. So I have a friend going through this now, and her husband is 20 years her senior, and he's in his 80s, and she's concerned about all this. So she's just investigating it. And most of their money, most of the IRA money, is that the same? Most of the IRA money is in his name.
right.
Is IRA the same as a pension or a
Well,
401?
IRAs are a bit different in the sense that they they're not subject to quadro, qualified domestic relations order. Pensions and 401ks are, IRAs aren't. So that's something that we would address separately from that. It wouldn't be an in marriage quadro to protect that asset, but could be other techniques to protect that asset.
Cool. So let's say you protected the assets and you switched everything over to the younger spouses, and the older one reaches 100 and passes away. And now the remaining spouse has all this money. Now, what do they do with it?
And that's a great question, because even though we talked about the house being exempt, it's only exempt when you're married and you have a community spouse that's going to live in the house.
Oh, now you're no longer married.
Once that spouse passes and you're no longer married, you're single, now that house is not protected. And so what happens is, as soon as you apply for Medicaid, the state will put a lien on your property in anticipation of getting paid back everything that they provide. It doesn't mean you lose the house immediately, but there'll be a lien so that once you go into a nursing home and the average stay is 3 years and you pass on from there, the state would come back and exercise their rights under that lien.
Yeah, I see that all the time in short sales. There's always liens on houses when elderly people go into a nursing home. But could you not put your house in trust so that doesn't happen? Even,
There are several things that you can do. And this is where the 5-year planning comes into play, is that if you transferred that house into an irrevocable trust, it could protect it. Many times what we see is the remainder is transferred to the children, and the parents keep the legal right to live in the property. They have a life estate. The value of that life estate is very de minimis, and so it doesn't inhibit people from qualifying for Medicaid. And yet the vast majority of the equity has already been transferred out under the 5-year rule, and so then the house is fully protected. And that's something that can be comfortably done.
So let's say this is like such great information. There's so much to know. And it's complicated because, you have usually two, one dies and the one's remaining, and then you have to worry about when that person could die too, or, you could guess wrong, like you said, somebody could die before the other. What about if you have a trust and you go into Title 19, do they take the money that the trust generates? Let's say you have, $1 million making, thrown off 50,000 a year, and you're using that now to live. Do they take that money into consideration?
Right.
The money that the trust earns?
Right. So as a Medicaid recipient, you can't have any income.
Oh, you can't have any.
Meaning, so to the extent that you do have income, it automatically gets swept to the state on a monthly basis. So for instance, Social Security. You might have a Social Security benefit. The institutionalized spouse, the Social Security, would automatically go to the state.
Oh, so like if you have a pension and a Social Security, that goes to the state to pay for your upkeep, to pay for your.
If you qualified, it would be the state would pay out the Medicaid benefits, but then they would get reimbursed on a monthly basis, by your Social Security and maybe a pension and things of that nature. You have to remember, the average cost these days is over $13,000. And
Yeah.
the state is paying the full amount. It wouldn't be 13, but it would be the full amount to the nursing home. And then they would get reimbursed for maybe $1,500 in Social Security and, $1,000 in pension and things of that nature. And
So if you have money coming from a trust, does that just go to wherever the nursing home?
it would. And more importantly, if you have money coming from a trust, those trust assets might disqualify you from even receiving Medicaid benefits.
Ah, okay, okay. So you can't even get it, even though, let's say you still can't qualify for 13,000 a month.
Right.
Let's say it throws off 5,000 a month, and so you still can't qualify.
Well, the problem is you might not be disqualified on the income side, but you'd be disqualified on the asset side because that trust may have 500,000 or more in it, and the state would say those assets are not exempt, and therefore you have to spend those assets down. And so, what do you spend assets down normally on? Let me just take a quick look of some of the things. For instance, prepaid funeral contracts. You can spend down up to $10,000 in 2020 in a prepaid contract. You can spend money on all your medical needs prior to applying for Medicaid. So, you go to the dentist, you go to the doctor, you get hearing aids, you get eyeglasses, you get things like that. That's another way to spend down money. And one of the other ways is to put the money into a house.
Into a house?
Into the house that you and your spouse, let's say, live in. Because
fix it up.
Fix it up, or pay down a mortgage that you have on it, whereby you could get rid of, let's say you had a outstanding mortgage of $200,000, you could take those assets and pay down that mortgage. The house is exempt because you're married and your spouse is still going to live in it. However, you've just gotten $200,000 out of your Medicaid estate by paying down the mortgage. You could also fix it up. You could, improve it, new kitchens, new baths, new roofs. You could put on an addition for a care provider to move in, things of that nature.
Paul, how long do you have to spend down the money?
You basically have to spend it down prior to receiving the benefit. So if you were over the limits that I talked about and we were discussing spending down, we would not apply until you actually spent that money down.
So it doesn't have to be 5 years before.
No, it does not. You might say, I need nursing home care. One of the other ways to spend down is to pay privately for nursing home or assisted living care. At $13,000 a month, you can imagine the spend down is very quick. And so you could spend down that way. And we generally recommend that clients have 3 months or more of private pay money so that they can have choices as getting into the best facilities that are available. So many institutions like to take a private pay patient at $13,000 a month, even for 3 months, and then they'll accept Medicaid after that. And it gives people choice as to what facility they might choose to get into. Yeah.
Okay.
So it's not an all or nothing. The idea of Medicaid planning is to save as much as possible, but understand that you're not going to save 100%. But if you can save 70, 80% or more, that's a home run in this industry.
So when should people come to you for the plan? Like what age, what stage?
Well, considering the 5-year look back, you have to come 5 years prior to really get
early, because you never know
any meaningful planning done. So when people have any types of events like retirement, like gifting to their family, anything like that, a new grandchild is born, that's the time to say, hey, do we have a plan? Do we have our wills in order? Do we have our power of attorneys in order? Do we have our healthcare directives in order? Who's going to take care of us on that front? And then as we address that, we can provide the elder law services in addition to the standard wills and trust services that we offer.
And does the 5-year look back have anything to do with, let's say you get Parkinson's and then you put things in a trust and then you don't have to go for another 5 years plus 6 years. Does that take into consideration that you're already sick when you started the trust?
And that's not really a factor. The idea of the 5 years is to avoid people from rushing and attempting to get rid of their assets under the old laws and then claiming that they needed the benefits. So the idea is that if you've given these assets away 5 years or more, then you're really in need of the Medicaid benefits.
So if a spouse has not planned correctly, and all of a sudden their spouse, a married couple, let's say their spouse needs to go into a nursing home quite unexpectedly.
Yes.
Is there anything they could do to protect things?
The closer you are to needing a nursing home or the benefits of a nursing home, the less that can be done. But there are still things that can be done. There's still dollars that can be saved. And so if you come in 5 years or prior, that's when we can do the most benefit. If you come in 5 days before, that's where we can do the least benefit. We might advise to hold off on Medicaid application and spend down in various ways, whether it be putting money into the house. You could still do that immediately, put money into the house. In 1 month, you could spend down a significant amount of money into the house, into a family car, into your medical expenses, your funeral costs. So there's still money to be spent. But the more you want to save, the earlier you have to plan.
So if, let's say you gave away money without realizing this, and all this. So let's say you gave away, let's say you helped your kids pay for a house, you gave them $200,000 down payment.
Right.
And now it's 2 years later. Are you just disqualifying yourself, or do you get taxed somehow on the money you gave away, or?
You are disqualified based on how much you give away. So if you give away $130,000 and the Medicaid benefit is $13,000 a month, you would be disqualified for 10 months.
All right, so you're not forever disqualified, just up to whatever you gave away.
That's right. And
because
so
basically they're saying you could have paid for yourself, but you just handed somebody else the money.
Correct. And so we review the last 5 years and we look at the gifts that you potentially made, knowingly or unknowingly, and we calculate, you're going to be disqualified 13 months, therefore we're not going to apply until month 14.
So what is the process for qualifying? Do they look at your tax returns for 5 years, or what do they look at?
They can look at everything for 5 years. So they can look at your accounts, your checking accounts, your savings accounts, transfers in, transfers out. They can look at all that to determine if there have been any gifts or transfers that qualify you. And because
do they look at everything typically?
Yes, based on applications.
And how long does that process take? And are you involved in that process as an accountant or as a lawyer, or who's involved?
Well, we do the planning side of it, but we also can make application for Medicaid benefits for our clients, and we do. So it's two separate steps. You might come in and we might provide you planning, and 5 years or more later, you say, well, now we need those benefits. Let's make application. Many times the facilities are involved in making application, but I always suggest having an attorney involved, whether the attorney's going to either make the application or just oversee the process, because a Medicaid applicant or a consultant may not know all the assets and all the things that we've been working on for the last 5 years. So you want to make sure that application is done properly.
And so are you like applying, is it a month or two prior to needing, like, should you stay home and have private care until you can apply? And how long does it take to get approved?
I mean, approval process can vary, but 30, 60 days, and you would be applying basically the month before you needed the care in order to get qualified. And at that point, you would have to review your situation, make sure that you're eligible. There's no point of applying if you know you're not eligible, because then you would just get disqualified until that time period ran out. So
what if you need emergency care? Like, you're it. You don't have a spouse, and you need to go to a nursing home tomorrow because you fell, you broke your hip, you can't go home. You don't know if you qualify yet. What happens in the middle part?
Well,
in the term?
First and foremost, you have to take care of yourself and the care that you need. And so many times people are paying privately, and if they have some money, they're thankful that they have those funds, and they use them to pay for these facilities privately, whether it be assisted living or a nursing home. And of course, that's going to spend down your assets significantly, and it'll get you closer to Medicaid qualification. So people do absolutely do. They do pay privately and spend down their assets in order to qualify. Right.
I mean, it is pretty funny. I mean, it's great what we're talking about and how to protect your assets, and especially a spouse that's remaining, and that's critical. So you're not leaving them, in the poorhouse. But that is why we work so hard, to make sure that we are taken care of when we're older, right? So it's not just about like hiding things and not having good care. It is about our care and our loved ones' care. It's about Absolutely. The care. You worked your whole life, and now you need care. And if the money's there, it's okay to spend.
It's okay to spend, and if you've done the planning, you're going to be able to save much. Someone who's done no planning, let's say, has $500,000 in their estate, they're going to spend that entire amount to take care of themselves. If they came in 5 years earlier, they might be able to save 80-90% or more of that money and still get the same level of care.
Wow.
So it's your money. You spend it as you wish, and plan for it as you wish, whether you want to spend it on your medical needs or be able to qualify for Medicaid. I mean, when it comes to middle-class families that have managed to scrape together after a lifetime of work their savings, this is what a lot of people want to protect, to be able to pass something on to their heirs.
That is amazing. I took like 5 pages of notes while you're talking. You're like a wealth of information. It's amazing.
Thank you. I appreciate it.
So much. Do you hand people a stack so you don't have to keep repeating yourself of like, here's the major points of things to read before you have a consultation, or are you consulting individually, going over everything with everybody over and over?
Well, the initial consultations we provide on a daily basis. We provide initial consultations on a complimentary basis, but the most important is the planning that we do together, specific to their situation, their asset mix, and their marital status and whatnot. That's really where the work begins.
Wow. And so my parents had an irrevocable trust, for instance, and then my father passed a few years ago, and my mom had to do something else with the trust, even though it was irrevocable. Why? If it's irrevocable, why do you have to redo when somebody passes?
Well, if an irrevocable trust is set up, it usually will have instructions in that trust that upon the demise or passing of the grantor, the monies are going to go to X, Y, and Z. And so generally, there's no need to reinvent that trust. But that trust should have instructions during one's lifetime and also after their lifetime. They might have been setting up a new trust for themselves.
They could have just revisited because it had been like 25 years that they had it. So I don't know. That could have just been what was happening.
Yeah, it's always a good time to revisit when a family member passes, and then say, well, how are we set up today for the ones that remain?
And do the laws change often? And if so, are they grandfathered from when you set up your trust?
They do change often, especially the Medicaid laws. Every year, the income limitations, the asset limitation, what's exempt and what's not exempt, those things change on a regular basis. So it's important to stay up to date on the plan. So you might initiate a plan this year, but then you might want to revisit it every year, every other year, just a touch base type of thing. Maybe there's nothing that has to be done. Maybe there's a new provision in the law that has to be addressed, or maybe you want to provide, well, I had another grandchild, how do I provide for their education, things of that nature.
Amazing. So much to learn. And I know you just touched the iceberg. If anybody wants to get in touch with you, this is the best number, right? Paul Bologna, 203-348-3555.
Correct.
We're downtown Stamford.
Yeah, we're providing contactless services, much like this, during this COVID-19 crisis. And many of our consultations and our planning are done via phone, via email, via Zoom. And then when it comes to signing documents, we can always get together in conference rooms and, respect the sick. Yeah.
Love it. Paul, thank you so much for coming on. And I know we've known each other for like 12 years, but I didn't know any of this information. So thank you so much. And you've been just a great wealth of information. And for everybody else, stay tuned tomorrow on Let's Talk Seniors. And Paul, I'm going to be saying goodbye to you now. So thank you so much. Appreciate it.
Thanks.
Bye.
Bye-bye.
Till tomorrow.
Hi, Deirdre here again. Thank you for joining me on Let's Talk Seniors Memory Care Issues. Is this an issue hitting home? Do you have a parent or loved one with memory care issues who you feel is not safe at home anymore? Are isolation, falls, and safety issues becoming a big concern? Welcome to Dogwood Senior Home, premier boutique residential senior living specializing in memory care. It's country living at its best in the Huntington section of Charlton, Connecticut. We're truly a home with only 6 senior residents living as one family unit. Senior residential homes are a concept sweeping the nation with 47,000 across the U.S. We're pleased to open Dogwood Senior Home as it will be only number 6 for Connecticut. Brand new, sparkling clean, opening mid-June. And safe, safe, safe. We are COVID-free. Residential care homes boast a very low COVID infection rate across the nation. This is due to the intimacy of size and speed in which the caretakers can shift to accommodate immediate needs. They are much safer than the large homes and facilities, as you can imagine. It has been documented that residents have less falls and a better quality of life in a residential home environment. Our home is more affordable than the big box facility. You pay one all-inclusive price, and that price is guaranteed for the life of the resident. With an incredible 1-to-3 caregiver ratio, which you won't find anywhere else. Our friendly, loving caregivers are dedicated and trained in Alzheimer's, dementia, and Parkinson's issues. We're only taking 6 residents, so the home will fill up fast. Call me at 203-689-7562 for a talk and tour. I would love to meet you and your loved one. See you soon. Bye.